driving under the influence. The key word to that is influence. You can blow a .00000 and get a DUI. You also do not have to be driving a motor vehicle. You can be riding your bicycle. Some states you can be riding a horse. Or as one guy found out, you can be riding your riding lawnmower. You could be arrested for a DUI even if you are not driving. If you have actual physical control of a vehicle while under the influence, then that can be enough for an officer to arrest you. Generally, actual physical control means that the driver is in the vehicle and could make it move. In Utah, however, you could be convicted of a DUI even if you had no intention of making the vehicle move. Having the potential ability to do so, even if you are asleep in a parked car when the officer finds you, can satisfy the meaning of actual physical control. This is not a DUI class, it's an alcohol server training class, but all law enforcement agencies in Utah work together for the end result of two words, which is called public safety. It all starts with the implied consent law. Utah law requires you take a blood, breath, or urine test or a test of oral fluids, saliva, if you're arrested for a DUI. Utah's implied consent law says that if you are lawfully arrested by an officer who has probable cause to believe that you've been driving under the influence, then you consent to taking a chemical test of your blood, breath, urine, or saliva for the purpose of determining your blood alcohol content, a BAC. The test must be taken as soon as possible from when you were last driving, and the officer gets to choose which test you take. In fact, the officer could ask you to take more than one test. You have to take all the tests the officer asks for, unless you want to face penalties for refusal. If you submit to the officer's test or tests, then you have the right to have additional tests taken by a medical professional of your choice. You do not have the right to speak to an attorney before deciding to take the tests. Refusing to take the test. Once you are arrested, the officer should warn you of the penalties for refusing a chemical test. If you refuse, your license will be revoked. Also, depending on your driving history, you could be prohibited from driving while there's any measurable amount of alcohol in your system for 5 to 10 years. Additionally, you might have to drive with an ignition interlock device in your car for 3 years. After you have been warned, you must tell the officer if you will submit to a test. If you refuse, the officer will take your driver's license immediately. In its place, you will get a temporary permit that is good for 29 days, and information on how to request a hearing to challenge your suspension. At the hearing, you will have to prove that the officer's belief that you were driving under the influence was not reasonable or that you actually consented to the test. If you fail to do so, or if you simply do not ask for a hearing, then your license will be suspended for 18 months if this is your first refusal. For your second or any subsequent refusal within 10 years, or if you had a prior DUI conviction within 10 years, your license will be suspended for 3 years. When 50% of all DUIs come from people drinking in on-premise licensed locations, the state of Utah has to act to fulfill the commitment to public safety.